All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. This is the time set for oral argument in the matter of Reyes versus Town of Gilbert, our civil number 18-0359. Each side will have 20 minutes within which to present their argument here this morning. Appellant may reserve some portion of that for rebuttal. But it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case. We think we're pretty familiar with the underlying facts and issues, so please keep that in mind as you make your arguments here today. The proceedings are being recorded, both by audio and video. And as you approach the podium, please identify yourself and your client for us. Thank you. With that, appellant may proceed.
Thank you, Your Honor. Good morning, Your Honors. My name is Robert Grosso, and I represent the town of Gilbert in this case. I'd like to focus my limited time in this case on two primary issues addressed in the briefs. One, whether the town of Gilbert violated Rule 26.1 by failing to produce a copy of what has been referred to as the 2003 Traffic Impact Study. And second, the trial court's interpretation of the Supreme Court case of Levy versus Parsons. I'm going to start with 26.1 because I think that's what kicked things off. If you look at the trial court's order granting a new trial, there's no analysis from the trial court, no substantial evidence in the record that the court walked us through to tell us how the town violated Rule 26.1. With regard to Rule 26.1, I think it's important to start with the rule itself. As Your Honors well know, Rule 26.1 requires parties to a case to voluntarily exchange certain information so that you're informing the other side what your case is about and the evidence that you intend to use to support your case. The first provision of that rule is that each party must disclose the factual basis for each claim or defense. That is significant in this particular case because plaintiff served, the record reflects, 24 disclosure statements in this case. The last disclosure statement is in the record at Appendix 197, Index of Record 307. Plaintiff's disclosure statements all contain the same factual basis for their claim against the town of Gilbert. It was articulated.
Mr. Grasso,
yes, sir.
Is it, just to jump ahead maybe a little
yes,
bit, is it your position then that looking at the plaintiff's disclosures, that the plaintiff's disclosures talking about their claim is what shapes and defines what is later defined in the rule as the subject matter of the action?
Yes, Your Honor. My simple answer is absolutely. That is the way it works in practice. We rely upon not only the pleadings that we get from a party, and if you look at the plaintiff's complaint in this case.
So the subject matter in the town's view would not be so broad as to encompass the concept of having anything to do with Ocotillo Road in and around the area of this accident.
Well, I think it'd be narrower than that, a little bit, Your Honor, because the reality of the situation is the accident happened after the paved portion, as Your Honor knows, on the dirt portion. The town understood, because in all the other thing that guides the town, in road cases, the issue under Coburn versus City of Tucson is whether the roadway was reasonably safe for motorists following the usual rules of the road at the time of the accident. So what's relevant in cases of this nature is how the condition of the roadway was at the time of the accident, not 10 years earlier, but on that day. Here.
But so does that lead you to conclude that a design study or a traffic study done in anticipation of development of the area that might have forecasted thousands of trips in the area is not relevant to the claim because what matters is how many trips there actually were at the time of the accident?
Let me, if Your Honor, if I could just step backwards. I think it's a good question, and let me just help unpack it. I think it's important to distinguish between what's sometimes referred to as traffic studies and traffic impact studies. Towns and municipalities don't usually develop roadways of this nature, so there's going to be a developer that does it. In this particular case, a developer, Fulton Homes, needed to have a traffic impact study so that they could understand what type of traffic, when you put in 800 homes, what was going to happen. Correct. So that doesn't dictate. Signing comes later.
Right, but
after the roadway comes in.
Doesn't it inform
Yes.
warnings and signage?
But the point of a traffic impact study, and if you look at the 2003 traffic impact study, it says it right at the beginning what its purpose is they want to know things about where to put what we call collector streets. I call them as people like side streets and stuff that gets into all the neighborhoods and stuff, whether they should be aligned, whether they should be offset. This one you'll see in the plans, it was originally offset and then later put in as aligned. So it's driving those decisions. A traffic impact study does not dictate signing or safety issues down the road, and it couldn't be used to support the town's position that the roadway was reasonably safe at the time of the accident. Because remember, this is a projection. This was done in 2003. The homes weren't in. Ocotillo Road was simply a completely dirt road.
So does your contention under the case law, that the information available to the town at the time that it decided what warnings were required 10 years before the accident, that's irrelevant. What mattered is the state of the road at the time, under the circumstances at the time.
Yes, Your Honor, absolutely. You got to remember, and it's also in the record too, that we didn't even the town did not acquire the right of way to all of that until like 2009, 4 years before the accident. So it was incumbent upon the town to make sure that the roadway was reasonably safe as it was put in. And you can use, and the case law is replete with this, signage to take care of issues with design, because you have to make sure motorists know where things are. Another reason Your Honor's question is particularly good in this case is early on, and the record reflects this, I want to make sure this is clear. Dr. Robert Blau was the plaintiff's traffic engineering expert. He's in all kinds of published decisions. For 26 years, I've done these sorts of cases, and he's got 40 years of experience. It's at Appendix 144. He was at the accident site within 2 months, less than 2 months of the accident. All of the reports that Dr. Blau, and the disclosures I got, 24 from plaintiffs, from Dr. Blau, all talk about it being a signing case under the MUTCD. And there's a particularly good reason for that. Dr. Blau knew he never reviewed the development file, which means that if the 2003 traffic impact study was in the file, Dr. Blau wouldn't have seen it. It's because Dr. Blau knew what the real issue is. In a case of this nature, it's driven by whether the roadway was reasonably safe at the time, and his position was under the Manual on Uniform Traffic Control Devices, what we call the MUTCD, you have to have object markers for objects that are either in the roadway, adjacent to the roadway, or for the end of the roadway. And that's the theory they went with. Dr. Blau's original theory was the canal structure that's above ground is an object in the roadway, so he advocated for type 1 and type 3 object markers. At trial, they argued type 4.
Did he say something different in his post-trial affidavit?
Oh, well, absolutely. It became type 4 object markers.
No, I meant about the relevance of this plan.
He did. He said, he broadly said it had this may have some implications related to design, but he doesn't take us to what that meant. What I think is significant when you're looking at this post-trial reflection from Dr. Blau, because now it's different from him, you have to analyze that in terms of what he's saying in conjunction with the other discovery from Kenneth Howell, the author of the 2003 traffic impact study. What's significant there, Your Honor, is both Dr. Blau and Mr. Voiles, who came up after the trial. I mean, like a year later, he shows up. What happened was we took Ken Howell's deposition. Ken Howell unequivocally testified that the 2003 traffic impact study, the counts between him and Mr. Kwasniak were consistent. But here was the most important thing. This assertion that there were thousands of cars heading toward the canal.
2,000.
It's patently false, Your Honor, and I can,
Patently
with the
false
record,
meaning
prove
it didn't
it.
turn out to be 2,000, or it's a false representation of the state?
It's a
the
false
report?
representation of the document, and I can prove it.
Okay, because I'm looking at,
does it
I'm looking
ma-
at the document. It says 2,000.
Are you looking at this, Your Honor?
No, I'm looking at page, okay.
This probably is, yeah.
Your Honor,
It's figure 5, page 12.
yes, let me be clear. This is in the record, and I would please look at this, okay? It's Appendix 326, we included it, okay? This is part of the 2003 traffic impact study. So what we did to make it easy for Your Honors in the appendix is we put red boxes in, okay? The red boxes on our copy will show you where they have the word, the 2,000, okay? That means that, remember, this is a projection for 2 years down the road, okay? So that means that the 2,000 in the red box is there, and then you're going to see just past where it's the 2,000 in the red box, there's a collector street going north and a collector street going south.
Your point is all those
So
cars are going to
all the
disappear.
cars are going into the development because that's what Fulton Homes, when they issue these, cares about, okay? They're not worried about, there was another 500 feet of pavement and then 800 feet, 2.5 football fields of dirt road. This has nothing to do with it. That's a red herring and a gross misrepresentation of what this stands for.
What is your response, though, to Voiles, who actually says something I think is more powerful than Blyle? Voiles says it's all about context. The decisions the city was making, the town was making at the time, need to be assessed in context. I'm not quite sure what that means, but what is your response to it?
Your Honor, I have done these. I have no idea what that means. Mr. Voiles was not an expert in the case. I didn't have a chance to cross-examine him or anything like that. The reality of the situation is it has nothing to do with anything because these traffic impact studies for this development dealt with isolated issues a decade before this accident, and it has nothing to do with how this isn't a design case. This was a straight shot. The vehicle went off the pavement, traveled for 2.5 football fields, and then hit a structure that was above ground because the driver that we showed at trial, there was overwhelming, unrebutted evidence, was grossly impaired at the time. We presented visual experts, we perception experts. Everybody said that if he had been traveling at a reasonable and prudent speed, the canal was visible, and our defense was no additional warnings were needed. It was causation that was causing it. Mr. Voiles' assertion is vague, it's conclusory, and it doesn't prove anything because nothing about this study relates to that portion of the dirt roadway.
So you distinguish between design, a negligent design of a road system from once you figure out where the roads are going to be and how wide they're going to be, the warnings that you...
Absolutely, Your Honor. That's what you have to do. Once the roads are configured and you have the widths and the configuration set up, then that's when a municipality comes in and does signing later. And there was a signing plan in the development file, which was disclosed in the case and marked as a trial exhibit by the plaintiffs. So without question, Your Honors, and I know I have such limited time, so I apologize, but I believe it's unequivocal in this case that Rule 26.1 did not require the town to do anything other than it did. And I want to be clear on this in the record. This document its existence was disclosed. If you look at Appendix 113, the development file had a review comment sheet from Bruce Ward, the then town traffic engineer, where he was reviewing it and doing red lines to it. This was something that was disclosed in the case. If Mr. Breyer wanted it, he could have done exactly what he did after the trial, asked for a copy of it. But even if he would have asked for a copy of it, it would have had nothing to do with the theory that he went with, that he disclosed in 24 disclosure statements that Dr. Blyle relied upon, and that we did in the trial. So I think it is the trial court simply abused its discretion with all due respect, concluding that the town violated Rule 26.1 by not producing a copy of this. I want to quickly say this as well. In Mr. Breyer's motion for new trial, you should look at it. He did not accuse us of violating Rule 26.1. He was blaming the town for failing to comply with a public records request. So there is a distinction there. That was something that Judge Bergen thought up on her own. That was an argument she raised and addressed, and I simply do not believe the record supports that proposition.
But the town didn't, but the town, the The study was called for by the public records request.
No, I think you need to, no.
Oh,
And here's why. Because the public records request was for traffic studies directed to the town. If anything, I guess it would be inadvertent. The broad nature of that, the town interpreted that to mean traffic studies that were discussed when the traffic engineer was deposed 2 weeks earlier.
Right.
Mr. Guderian was asked about signage, because remember, it's a signage case. And what he said was, Mr. Breyer asked him at his deposition, he said, isn't there occasions when the town will, like somebody will spot a problem after a roadway's in and the signs are in, and somebody will say, we think there's something wrong, will you come put more signs in? And so Mr. Guderian said, yes. We then go out, we do either a field review, we look at it to see if it's something where we put a stop ahead sign or something in, or we do a traffic study. Then we get the public records request for the traffic study directed to the town, and the town answered it correctly. We didn't do any traffic studies afterwards. The town didn't interpret that to mean a traffic impact study done 13 years earlier by a third party.
But it was, the study was in the file, and I mean,
It was
yeah, called for.
Well, it was in a separate department at the town, yes, Your Honor, and I don't think anybody knew that. But again, I think the point under Rule 26.1 is whether we had an obligation to go track it down. It was disclosed and go pull that and give it to them. Then the big question is, and that's why I want to get to the courts before I'm really running out of time, levy versus parcel. Please, because I think we're missing two big things here, and I want to make sure I get it out. The Supreme Court says, it's under Headnote 1 and 2, quote, reversal will be required only when it appears probable that the misconduct, quote, actually influenced the verdict. Justice Feldman left that in place, okay? And the reality is there's no analysis. The trial court implicitly acknowledged in her order that it wouldn't have affected the verdict in this case, in the signing case. That's why she says, well, this could have opened the door to a new legal theory. She expressly says on page 5 of her order that she's not going to consider whether or not it would influence the verdict. And, Your Honors, that was an error. This is absolutely clear from the Supreme Court. And finally, I want to also say this. When she's talking about how she can presume, Your Honors, they can presume prejudice, the quotation is leaving out the last sentence, and it's very clear when it lists the 3 factors concerning the misconduct that would give rise to the inference. Justice Feldman wrote, in cases in which these factors are present, and we don't have an analysis of that, prejudice should be inferred absent an affirmative showing to the contrary by the guilty party. We presented evidence clearly demonstrating it wouldn't have made a difference in this case. We completely, with the discovery post-trial, debunked the suggestion that this impact study would have mattered during this jury trial. Plaintiffs had their opportunity to try a signing case. They had all the due process in the world. They litigated the case for 3 years. And the reality of the situation is it wouldn't have changed the result.
Would you please remind me of this, the name of the case that you started out citing about the test on a design case?
Oh, Coburn versus City of Tucson, Your Honor, and I apologize, I don't have the site member.
COB?
Yes.
I'm just not seeing it. Okay. Okay.
The standard about roadways need to be
Yeah.
reasonably safe for motorists following the usual rules of the road.
I'm not
Yes.
seeing that in your brief, but okay.
I apologize, Your Honor, and if I could reserve the rest of my time, I'd appreciate it. Thank you, Your Honors.
Good morning. Mark Breyer for Joseph Reyes. I want to start with something the court well knows, but make sure because I may be referring to it, and I want to be able to shorthand it. The standard review starts with the fact that we're dealing with a judge's ruling on a motion for new trial and therefore an abuse of discretion. However, as the court's aware, because this is a granting of a motion for new trial, there's even more deference. However, in this case, we actually have a trial judge who sat there for 2 weeks who, when she got the motion for new trial, said, that's not good enough. I'm not going to make decisions without more evidence, and put us on an 8-month hold of discovery so that she would have no doubt. She got 2 expert affidavits, a deposition of the person who did the study that wasn't disclosed to us, and then, after all that was said and done, there is no record provided to this court from which this court could possibly question, and of course the appellate court will presume that the record supports the decision of the trial judge if it's not provided. The reason I say that is so many of the arguments made both in oral argument as well as in briefing by the town are a believe me, trust me, this is what happened, the judge has already decided it. And she decided it after a 2-week trial of sitting there. She decided it after sending us back for more evidence. That's
Counsel, she relied on the affidavit submitted by the experts. And what in your view, is the most compelling component of those affidavits that suggests that there would have been a difference had this information been available?
Well, I would answer in 2 ways. First, I don't believe under Levy, the court, when there is misconduct by a party that refuses to provide something that's requested in our initial deposition in the case we asked for, if the court looks at the 30B6 deposition, the first thing we ask about to their town engineer, the very first thing is, and the very first statement relates to, we want to talk about the development of this road. Then we ask for it in a request for production. Then we ask for it in a public record request. And if we believe the town, they literally sat there with what my expert, and I'll address the court's question in one moment, but my expert called the smoking gun. Someone who does traffic impact studies for a living. That's what he does. He's hired. He does it. That's his expertise. He called this document that they didn't provide, that we had requested over and over and over again, as the trial court found, the smoking gun. They sat there with the smoking gun in one hand and Rule 26.1 in the other, and they said, no, we don't have to give it.
How is it a smoking gun going to your theory of signage?
Well, I don't think it's as simple as signage. As Dr. Blyle made clear, he would never have asked for the development file if it did not include a traffic study. And that's because without the traffic study, we have no idea that there's 2,000 vehicles coming and going a day, which tells us how we have to design the area. If there were 3 cars coming and going a day, that's different than if there's 30,000 cars. So knowing the amount of traffic that is heading towards a canal in the middle of a road that runs through the entire East Valley and only has one place where it is not a fully developed, fully signed road, is right here where it ends at a canal.
But we just had a discussion about how that report, and I was corrected, doesn't say that there are 2,000 cars going, intercepting the transition from pavement to dirt. Most of the cars, all but 120 something,
Right.
turn off before they get there. So how does, that number's consistent with what the experts all thought at the time. So how is it material?
I would not agree with that statement. I would broaden it. First of all, what it tells us is that 1,000 vehicles a day were going to head in the direction of the canal.
Okay.
Okay. We didn't know that. We asked for it.
But how does that matter here?
Okay. The reason that matters is what both Dr. Blyle explained and Mr. Voiles explained is that if you know there's 1,000 vehicles heading towards the canal, you know, and by the way, the deponent who did this study, he agreed with both these experts that we know that people will be lost. We know people will be confused. We know people will overshoot their destination. So the more vehicles that are heading towards a canal in the middle of the road that is unmarked, no cul-de-sac, no barrier, the more likely somebody is going to be hurt. And what I don't know if
Okay.
so the answer to the question, and this is not my answer, this is the answer of Mr. Howell, the person who gave the deposition who did this, Dr. Blyle, the person who testified in the case, and Tony Voiles, an expert on traffic information studies, all said the very first thing a town does when they're developing a roadway, this is the requirement. You need this data.
So the notion is to design the signage, or to decide what signage is necessary, you need to know how many cars are going to be heading in that direction, and from there you infer how many will miss their turnoff.
Well, that's what Mr. Howell testified
Okay.
to in his deposition.
Okay. Now, how does that relate to the case authority that Mr. Grosso has cited for the proposition that decisions the town made 10 years ago don't matter? What matters is simply whether the warnings are sufficient right now.
Because the problem with that is explained by our expert, and as the trial court found, Your Honor, is that first, as Dr. Blyle said, had I been given this document, I would have had a theory, one, related to signage, and two, there would have been broader theories because I would have actually had the document that I need as a baseline. So what
is that broader theory? Why does that number change the theory?
Because we had, in spite of requesting it, and in spite of taking depositions, and in spite of people denying it in depositions, and although the court doesn't have the trial record, in spite of the fact that I took 1,700 pages to their traffic engineer in front of the jury and said, is there a single document in here from which we could know that the first thing a town's supposed to do, and that is this study, was done? And of course, the court doesn't have that because it wasn't supplied. So if we had, in fact, had that, what Dr. Blyle and Tony Voiles both talk about are options of putting up a barrier in the road, having a cul-de-sac end in the road. There are all sorts of ways that they can stop cars on a main road from running into a canal without no signage, no anything. So to basically reward the town for not giving us this document and go, well, the only theory your expert came up with at that time was, hey, from the information I have, they should have had signage under the MUTCD. Well, signage is a design question. And this, by the way, this notion that we hadn't disclosed it, if the court looks at our complaint, design is talked about in our complaint. If the court looks at every disclosure statement, design is talked about in our disclosure statement. The very first deposition we took in this case was a 30B6 deposition of whom? Their town engineer, and the first thing we wanted to talk about was development of the roadway.
But trying to get to whether it matters, isn't it true that the actual traffic count at the time is just what the traffic study would have forecasted? A plus or minus a dozen cars a day?
Can you rephrase that, Your Honor?
As I understand it, your expert counted the cars.
No.
Or maybe it was,
No, it was the town's expert.
Okay, the town counted the cars. And it showed roughly what the study would have shown, what the study forecasted. So how does it matter?
The fact that it showed what the study forecasted is a powerful piece of evidence for the plaintiff in this case.
Why?
Because had we had it at the beginning, Dr. Blyle said, if I had been given this traffic study, not only would I have talked about type 4 signage, but I would have talked about how they could have possibly used any engineering judgment to let this road simply end with a dirt road at the canal. And if I can take that a step further, Your Honor, Dr. Blyle and Tony Voiles talk about the fact, and the judge who sat there for 2 weeks looked at that and said, you denied the plaintiff this study that is study number one in this case. So the court's asking, how would it have made a difference? Well, if I was arguing in front of the jury, I would have been able to say, look, they knew this was, so their expert, Your Honor, just to start at the beginning, their expert testified, Dr. Kwasniak. The very first question he answered to the jury was, they have no data, I have the only data. And the court talked about that. Dr. Kwasniak over and over and over said, the only data in this case is mine. And therefore, members of the jury, you should believe that the data supports us.
Mr. Breyer, let's step back for a second
Please.
here. You hired Dr. Blyle,
Correct.
right? Did he go out and look at the accident scene?
Yes.
All right. He's got an extensive experience in traffic issues, road design.
Correct.
He walked the scene, I assume he saw the canal, he saw where the pavement ended.
We know he did that.
And are you arguing that he was somehow foreclosed from conducting his own traffic impact study and developing whatever road design theory he thought was appropriate?
No, what I'm saying, Your Honor, is first of all, I don't know if he could have just gone out to the town of Gilbert's Road and laid down everything he needed to do the study back at the time he saw it. I do know that by the time Dr. Kwasniak went out.
Was there any request made of the town for him to do that?
No, there was no.
Was there any denial of access?
No, Your Honor. But and the reason that is we never got document number one. What the court's question assumes that this document, that if it was unimportant, I would ask the question, why did they decide not to give it to us?
I candidly, Mr. Breyer, I read Gillespie's deposition. I didn't see in there that you questioned him about traffic impact studies or numbers, and I've looked at the request for production that followed from that, and it related to a plan that was then produced by the state. It was not, that request for production did not call for production of any traffic impact numbers.
Well, I read the production first. I read the production very differently because I asked for the entire comprehensive plan that Mr. Gillespie had testified to in the deposition.
But that related to his testimony in the deposition. He was referring, you have to put it in the context of the question and answer.
I wonder how the town saw the public records request as anything other than a specific request for this document.
We're not talking about the public records request.
I would argue that at the time of the 26.1, if you provide immediately after that 1,700 pages, and you take out 66 pages which, by the way, the town has said in a footnote, which would like the court to believe, that that's not contained in the development file. But at trial, Mr. Gillespie said, yes, that document is contained in the development file. So there's a document normally contained in the development file, according to their expert, that wasn't provided at the time we asked for it. I wasn't able to give it to my expert. My expert said that had he had that document, he would have brought in the theories. And the court's saying, well, why didn't he brought in his theories without it? Because to our knowledge, no one was going to be able to get us this document to show 1,000 vehicles a day at the time this roadway was designed were expected to go down towards the canal. I mean, I guess to me it is incredibly compelling that a party refuses to give a document in spite of being asked for that document, and then would ask this court to just presume that there was no material prejudice when the judge who sat in the trial found that, in fact, she thought there was material prejudice to the party. And ultimately, that's what's being requested.
Is it true that Dr. Blyle did not review the development file?
It is absolutely true. And as Dr. Blyle explains, he wouldn't have wanted to review the development file. The development file is largely...
But your problem is that this is it's very interesting to me that you say that what happened is that the town took the TIS out of the development file before it produced. And so I want to know what's the consequence of that. But if Blyle wasn't going to look at the development file, does it make a difference?
No, it's not that he went to look at it. I, as an attorney, Your Honor, have to make a decision as to what documents do or do not go to an expert. I can't give, if I give every expert every document in a file,
Cost more.
Through the roof. So the risk of any document I don't give any expert as a trial lawyer is that I have to ask myself, is there any way on cross-examination the failure to give this document can hurt? The development file is filled with a bunch of emails about side streets, literally down to coloring, like things all over the place. Not a single bit of evidence that I actually could provide to my expert that to me would inform him where he'd be able to say, hey, look at the data I have, which is particularly troubling when Dr. Kwasniak gets up on the stand and talks about data.
Right. Getting back to one more point, then this is just an isolated point. When did the issue of a Rule 26.1 violation come up in the new trial process? Mr. Grasso said that you didn't cite it as a violation in your motion for new trial. Is that right?
Your Honor, I will have to simply admit that I don't remember. I know for certain that what was incredibly frustrating to me is to find out on the day of the verdict that I had not been given a document I had requested. With all of the evolving case law and rules and everything throughout my career that has made 26.1 bigger and bigger and bigger, to find out that a document that got talked about in trial by their expert, by their witnesses, literally it appears that while the document was sitting on counsel's desk, he was arguing to the jury about the document. So to find out on the day of the verdict, after a 2-week trial and 3 years of litigation, that the document wasn't given, there is no doubt that my focus was on the fact that under that public records request, I cannot conceive of an honest argument by which we were not asking for that document. I don't understand how you could possibly read that as anything other than saying, look, we've gotten this far, we've asked these questions, where is the document?
In the expert testimony in the post-trial proceeding, I understand from what you're saying that that one important aspect that you were hampered by is you weren't able to say, your experts weren't able to say, I've looked at the data, I've looked at the 2000 number. But what?
No, it goes beyond that, Your
Well,
Honor.
that's
Dr.
my question.
Kwasniak
What
gets
else?
up on the stand.
What opinion would they have given?
But they said in their affidavits, their opinion would have been that if you have that many vehicles coming down the road, then you need to look at barricades, which apparently they had but denied. You need to look at cul-de-sacs, that there are other design options. When we're talking about signage versus cul-de-sac, all we're talking about is design, and the design is based upon the data. And their expert got up on the stand and said, data, and the only data belongs to me. And I said, where is the data from the traffic impact study, which this court doesn't have because the appellant didn't supply it. And I wasn't able to cross-examine Dr. Kwasniak in front of that jury and say, Dr. Kwasniak, the substance of your opinion is that the data supports the fact that there's only 12 vehicles a day going down that road. Number one, not true, because by the time he did his study, they had already had subsequent remedial measures, which would have presumably or potentially decrease the number of vehicles going down there. Number two, Dr. Kwasniak, you're telling the jury there's 12 vehicles a day that are getting to the road, and in fact, there's 1,000 vehicles a day that are heading there, and you know, and I would have deposed Mr. Howell then, because I would have known about Mr. Howell, and you know that Mr. Howell has said he expects as many as 5% of all people to be lost at any given time, and therefore you could have up to 50 vehicles a day, which may well have been the number. And on top of that, there should only be 6 vehicles a day getting to the first checkpoint and 0 to the second. So we have 6 to 12 vehicles a day getting up to the canal. Now, to me, in a case where the jury got the case after 2 weeks before lunch, deliberated all day and had to come back for the next morning of deliberation, the fact that I could have said to their expert, smoking gun right here, how are you going to tell this jury you have the data when the data says that way too many people are heading straight to their canal, and it takes one person to end up paralyzed or dead or with a head injury? You can't run into a canal and get whiplash generally. And what was stolen from me is my opportunity to say to their expert, and it was their expert's choice. He didn't have to say data, data, data. He must have said it. Court doesn't have it. But his whole testimony to the jury was, I have the data, and the data says 6 cars, and for 6 cars you don't have to do anything. It wasn't true. The data said 1,000 cars a day. 1,000 are going there. The data said 60-some cars a day are missing their turn. Now, I would think if a jury takes 2 days to come to a decision, it is pretty I would say it is beyond probable that had I been able to undermine their expert on his key point to show that 60 people a day are lost or confused or heading too far, that might have been a pretty powerful point that might have tipped the scales. This was not a defense verdict. It was a non-unanimous defense verdict after 2 days of deliberation, after 2 weeks, and they stole my ability. And they didn't just steal it because, well, we didn't know that's what you were asking for, because how can they even argue they didn't know what I was asking for, at a minimum in the public records request? And then instead of doing a mea culpa, which I would expect in what I consider to be a gross violation of our discovery rules, and at a minimum, they literally argue, well, we didn't give you this study because when we read your public records request, we looked for a way to go, yeah, that's probably not what it means. And anything other than supporting what the motion for new trial, which I don't think is a new trial. I think it's the very first trial my client will have with the ability to say to Mr. Kwasniak, or Dr. Kwasniak, I can't remember if he has a PhD, but to say to their expert, Dr. Kwasniak, you want to rely on data, but you know 60 people a day are heading towards the canal before they figure it out. 6 people a day are getting close to the canal when they're figuring it out. This is a case where any comparative fault is significant comparative fault because of what happened. And it wasn't an accident. They admit in their briefing, as they did below, that they looked at that public record request, looked at it and said, that must mean something different because I'll just go read this deposition from 2 weeks ago. How can we in Arizona that started the Zlacket rules, that has done nothing, even the new set of rules, everything we do is talking about disclosure, 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 have a plaintiff lose a trial after 2 days of deliberation, find out in the jury room that the study he asked for is important, have the trial judge who sat in that trial for 2 weeks find that she believes it materially prejudiced the plaintiff in a case where their expert relied on the fact that he had the only data when in truth it was sitting on defense counsel's table at the moment he was saying that. How I cannot have the ability to say to their expert, show me where this document exists. It takes a lot of nerve to suggest, by the way, that I should have known about this document. Number one, the document they put in there doesn't say a thing about traffic counts. Number two, in closing, they argued they don't know where the study is. In the record, the court doesn't have. I asked both of their engineers on the stand. In one, I literally picked up the box, put it in front of the engineer, and I said, show me where the data is because Dr. Kwasniak's coming up, and they didn't have it. We have the right in Arizona to expect that if we ask for something, we get it, and if it relates to the subject matter of design, which was in my complaint and my disclosure statement, we're going to get it and be able to use it. The court has no other questions.
Thank you.
Thank you.
Nothing in plaintiff's complaint put us on notice that this was a design case. Nothing in their disclosure statements that you're free to look at would put us on notice that this was a design case. First, because I have very limited time, I disagree with Mr. Breyer's assertions about what happened in the jury room. That was stricken by the trial court. There's case law in Arizona that was cited during the oral argument. Not only do I disagree with it, but it is unethical in Arizona under Martinez versus Schneider Enterprises for Mr. Breyer to bring it up and to sign a declaration about we allegedly talked with the jury about during deliberations. The document was never asked for. Dr. Blyle has been testifying, it's noted in published decisions for more than 40 years on traffic engineering issues. Mr. Breyer had Dr. Blyle was retained in this case on July 20 of 2013. 2 months after the accident, Appendix 144. Their complaint was filed 5 months after Dr. Blyle's retention. Their disclosure says that Dr. Blyle visited the site 2 months after the accident, took 20 photographs, and then concluded that we violated the MUTCD. Dr. Blyle knows what a development file is. After 40 years of doing traffic engineering cases, the fact that he never looked at it is telling because it wasn't relevant to their case.
Is it true that the TIS was in the development file but was removed before production of the
Absolutely
development
not. I apologize, Your Honor, I didn't mean to cut you off. Absolutely not. There's been no evidence to suggest anybody consciously removed the traffic impact study from the development file. The development file has that review comment sheet that highlights its existence, Appendix 113, where it shows that the town engineer was reviewing the traffic impact study for Freeman Farms. It cites to page numbers, paragraph numbers, and talks about it. So its existence is in there. They knew about that. And obviously, if Mr. Breyer was worried about traffic impact studies, because that's what he was looking for, then he would have noted this and given it to Dr. Blyle. I can't even fathom, I've never seen a case where a traffic engineer wouldn't look at the development file, unless the traffic engineer was out there 2 months earlier, concluded that it was a signing case, which is what it is, and was able to reach his conclusion without looking at the development file. After litigating for 3 years, I respect Mr. Breyer enough to know that he wasn't trying to simply save money in this particular case, given the nature and gravity of the case, that he would have provided this to Dr. Blyle. Something else that's important. Please read this in our brief. The development file contained a traffic impact study from 1999. That traffic study clearly says that 10,021 cars are projected back in 1999, 4 years earlier, to be servicing the Freeman Farms development. So if there was a traffic impact study in the development file that projected these 10,000 cars, that's undisputed, Mr. Breyer can't dispute that, then he could have, they could have gone with that. The 2003 traffic impact study just reinforced what was said in the 1999 traffic impact study. The reality is it never had anything to do with anything. They had all the data that they would have needed to make this case if they were going to make it. And the study that he referred to during the time of trial, what Mr. Breyer was arguing was this. You need type 4 object markers to warn people that the canal is in the middle of the roadway. He wanted the town to produce a study that showed that it considered type 4 object markers and ruled it out. The town's position is we didn't need to do that. That's what the argument was. His argument was never looking for a traffic impact study. I apologize.
I understand. Thank you. Thank you, counsel, for an interesting argument. We also appreciate the briefs that were submitted in this matter. We'll take this under advisement, issue a ruling in due course. We're going to stand at recess or allow parties to come forward with the next case.